Thank you.
Sorry.
Thank you, dear Monika, for kindly introducing me. I'm honored to be a part of today's discussion dedicated to the Supreme Courts in Poland and Ukraine. And I'm sure we have much to share and learn together, considering our historical background and the future aspirations. Of course, in my point of view, our Polish colleagues are several steps ahead in their understanding of the whole picture of the joining process to the European Union, its challenges and its consequences for the judiciary. And for Ukrainian judges, it is a long way ahead to adapt the court practice and procedures and the work methods to the supranational legal system and to go through a huge transformation process. So I will represent my thoughts concerning the current challenges for the Supreme Court in Ukraine and possible ways to address them, and I'll try to do it most objectively and ethically, considering I'm a former judge of the Supreme Court. Basics before I will move on, in case we have students in our audience. The new Supreme Court began operating on the 15th of December 2017, and it retained the power of cassation review, and it got a new structure composed of the Grand Chamber and 4 cassation courts, according to 4 jurisdictions: administrative, commercial, criminal, and civil. Currently, it consists of 158 judges out of 200 stipulated by the law, including 21 judges of the Grand Chamber. And I can say in advance probably that about 100 judges of the Supreme Court are eligible for retirement. It may play a good game, it may play a bad game, considering what time they will decide to apply for such a retirement. So the Supreme Court in Ukraine is a result of the most comprehensive judicial reform started in 2016 and introduced a large number of innovations, the new tools to ensure the unity and coherence of the court's practice, the new procedure for referring to the Constitutional Court, model case procedure for the administrative jurisdictions, and etc. Many others. Unfortunately, we are limited in time to describe all of them, but just to name them. It was a lot of work done, especially first and second year. We've been overloaded by the number of cases. And my concern is that all the previous work of the Supreme Court turned out in a shadow on the background of the high-profile corruption case. And you probably heard about it. And it's very disappointing to observe how easily we can lose something we've been building with huge efforts. And the interesting phenomenon is that the general public has less trust and interest in the legal positions of all the courts as a result of the crime conducted by one judge. So, as far as it is a huge blow to the reputation of the whole system, it makes it easier to manipulate public opinion and incitement not to trust to the courts. And these manipulations may be done by politics, may be done by civil society activists, who are not always constructive and sometimes rather destructive. And I should admit that the political intentions, which initially appeared in 2019 to reform the Supreme Court as an institution again, immediately become justified for civil society after the corruption scandal. And in June 2023, the National Security and Defense Council of Ukraine decided to enhance the fight against corruption in the judiciary as such. And in response to that decision, the Parliamentary Committee on Legal Policy prepared the draft law as regards the introduction of additional procedures to enhance public trust in the judiciary. And you probably heard about the legislative initiative in Ukraine to check the integrity of judges with the lie detector. This initiative was criticized by the Venice Commission in its opinion as of 9th of October 2023. From my point of view, I would like to emphasize that a special extraordinary integrity check of the Supreme Court judges can only take place after the lifting of martial law in Ukraine under the European standards of judicial independence. And in case it will be done, and in case the number of judges of the Supreme Court will be reduced, there are two different options, two different directions on further development of the Supreme Court as an institution and improving its capacity. The first one is recruitment of new judges up to 200 as it prescribed by law. And the other option, the other direction is transformation of the Supreme Court into a court with a relatively small number of judges, which will require significant changes in the procedural law and reasonable restrictions on access to cassation review. And talking about the solutions and perspectives for the Supreme Court, in any way, the Supreme Court needs to improve the procedural filters, and certain transformation, as I said, may be need of its structure and working methods, depending on the number of judges which will be serving in the future. Then the huge issue, I would say, and I should admit that the influence of the old law school and Soviet heritage within the legal practitioners circle is still significant. I'm not talking just about judges, I'm talking about advocates and other members of the legal practitioners circle, so to speak. I would say that in comparison, the academic world is adapting much quicker because of possibility for self-development and constant learning. And judiciary being the closed system, closed circle, adapts much more harder. Old school judges are not ready for changes, not so open for changes. They are very careful. They hardly can admit their mistakes and work them out. But however, and anyway, in order to prepare for the European Union accession, we need to educate judges, not only about the practice of the European Union Court of Justice, but also about European Union law and basics of European Union law, Council of Europe law, foreign languages. The vast majority of judges never studied European law, never studied European Union law, never studied Council of Europe law, and to support them, the solution may be, I'm not talking now about the educational process and training process, which is a separate topic to discuss. But in the structure of the Supreme Court, it may be supportive to compose a research and documentation unit to help research and analyze legislation and case law, monitor international European Union legislation and the case law. The other solution and the other need, I would say, is the strategy of the Supreme Court, and which probably should be approved by plenum of judges for every 5 years. In the Ukraine 2023 report of the European Commission on European Union enlargement policy, among the other recommendations, was the following: a new strategy for the reform of justice system to respond to the challenges of wartime still needs to be developed in a transparent and inclusive manner and adapted. Of course, it's understandable that this requirement is general for the whole justice system, but otherwise, it can ensure the stability for the judiciary and hopefully make a secure plan of action for 5 years instead of unbalanced and non-systemic reforms. As underlined by the Venice Commission in the above-mentioned opinion, following presidential elections, the new political power would often start new changes to the judicial system. In the absence of a holistic approach, various pieces of legislation were adopted that didn't have the character of a comprehensive reform. Of course, it has a negative influence on judicial independence. So last but not least, what I would like to emphasize is the need to ensure internal and external judicial independence, which shouldn't become a systemic problem. However, the bell rings regularly, I would say, starting from the judgment of the European Court of Human Rights in the case Agro-Complex against Ukraine in 2011, and then several judgments for last 7 years, I would say, such as Kulikov against Ukraine, Denisov against Ukraine, Samsin against Ukraine, Ovcharenko and Kolos against Ukraine, and others. And the opinion of the European Commission on this matter is the following. Despite the legal and institutional guarantees, the risks on undue internal and external interference in the work of the judiciary and the prosecution service persist, and further efforts by the competent institutions are needed to effectively reduce them. So as a conclusion to what I said, despite of differences in our legal systems, I mean, between Poland and Ukraine, there are still some universal issues such as trust in the judiciary and independence of judiciary and many others, which we may share and learn our lessons. And probably it is impossible to be perfect in contemporary world, but at least we may be good enough today, and we may be a little bit better tomorrow. And it can be a reasonable approach in case we will learn and work out our mistakes and will not take them again and again. So I hope it is a realistic and positive conclusion to what I've said. And of course, we are limited in our time to describe all the challenges and all the solutions for the judiciary in Ukraine and for the Supreme Court in particular, but hopefully I can answer the questions in case they will be answered. Thank you so much for your attention.
Thank you very much for this clear and communicative presentation of the current situation in the Ukrainian Supreme Court, outlining the main problems and challenges facing the court to date, and also including this, of course, difficult problem of corruption. And thanks for setting out the directions for reform of the court. It was also, I think, quite important, especially in the context of the second presentation. So we will move now to the Polish Supreme Court, and also a lot of problems that are connected with this court and the current situation in our Supreme Court. And I would like to invite Professor Paweł Wiliński to take the floor. So Paweł, the floor is yours.
And thank you very much. I will start with saying that I'm very grateful to Professor Kristina Trykhlib and Professor Monika Florczak-Wątor for inviting me to be a small part of your excellent research. I'm always very happy when I see this cooperation between Ukrainian and Polish lawyers, and this lesson that we are closer than we would ever thought. It's really great, and I still have these lessons again and again. As Monika said at the very beginning, she mentioned the Sunflower Foundation, and let me spare one of my minutes to tell you something about this. The Sunflower Foundation is foundation organized shortly after the February 22, the last part of the aggression against Ukraine. It is an international organization, NGO, and its aim is to collect information about the evidence of crimes committed by Russia on the territory of Ukraine, with the intention to give a valuable source of information for tribunals, either in permanent ICC or ad hoc tribunals, either country supreme courts acting under universal jurisdiction. So what we do not collect evidence, but we try to get information about evidence. And when the trials will start pending, we will be able to give them objective information about the evidence to be sure that this evidence will be admissible under international rule of law standard. So if you will have at any chance opportunity to support this initiative, it works also in Ukraine, and Dr. Adamska-Galant is also a part of the council of this foundation. We welcome all of you to join us or to support in collection of this information. And now going back to the direct point, Professor Tetyana Antsupova said that we Polish are several steps ahead. I'm not very sure if this is true. Of course, I am familiar with the problems that the judicial system in Ukraine face, those that arrive from the situation that this is a country that have been attacked by the neighbor, a huge neighbor, and every judicial system would face problems. But also those arriving of problems you mentioned. I work with my colleague, Professor Hanna Suchocka. She is participating in procedure of nomination of members of the Constitutional Court currently in Ukraine. So I am familiar, but I still say I am not sure if we are so many steps ahead, because many problems that we face today are similar to those that Professor Antsupova has just described. So I will refer to 5 points if I will speak not too long. Those points will be connected to the problems that we face as a Supreme Court within the legal system, and the problems that we suffer as the Supreme Court after 8 years of fighting for the constitution in Poland and for the rule of law. So as I see that, what are the current challenges of the Supreme Court? I would say that the first problem is that our law is unstable. The state of law and the stability of the judicial duties are the most important problem of the Supreme Court. In unstable situation, unstable law, it is very difficult to adjudicate, and all we do is to stabilize the jurisprudence or create jurisprudential lines. But when the system is very unstable and the politicians are very proud of changing the law again and again, and trying to convince society that changing the law is the answer for problems, the role of the Supreme Court and any other institutions that want to stabilize is very difficult. We have lots of problems. To give you two evidence, the first is the legislation that was connected with the COVID legislation, with the COVID period. So the government invented lots of strange regulations that we have to face with. One of them was introducing extension of limitation periods of przedawnienie. How to say przedawnienie?
Statutory limitation?
Yeah, statutory limitation. So There was a rule saying that during the COVID, the statutory limitation is not is not pending. So it was found unconstitutional, but just lately. And the Supreme Court had a problem whether it should open its own argumentation on the constitutional grounds, if it should include the constitutional, its own constitutional argumentation, or should wait for the Constitutional Court. It's, of course, problem because the Constitutional Court is not functioning in Poland. I would say it's functioning on 10% of what it was when we both with Professor Florczak-Wątor worked there. So we know how it is, how bad it is now. So we have the need for direct application of the Constitution in in current cases, and this is a huge problem. For example, we have the problem of the fees of defense in case of defense lawyers, and just 2 days ago we just received a new regulation, but before we had the problem how to implement the standard of equality between lawyers in this. So this is a very huge, I would say, sector of problems that we have. The second one is connected with the problem that the scope of adjudication of the Supreme Court today is too broad. This is, of course, a result of the culture of changing the law and all, I would say, Soviet kind way of thinking, that there should be always any appeal, there should be any procedure for everything, and then 2-instance court is in fact 6-instance court or even more, and for every decision, each and every decision, you need to have an appeal. So it is more like administrative law applied by state organs than adjudicating by independent judges. So we face this. For example, the Supreme Court in Poland, it sounds very strange probably for you, but according to the law in Poland, Supreme Court is an appellate court in military cases. So we are obliged in military cases to do the evidence and to give the verdict as the court of the second instance, and after that, of course, as a cassation court. We have lots of unnecessary proceedings that they are pending and taking time. And for these reasons, I believe this is one of the reasons why Supreme Court is overcrowded and cannot adjudicate in time. The third problem is systematic problem of the Supreme Court, and is connected with the last 8 years situation when the political powers, those that ruled Poland, they had an idea that also the judiciary should be subordinated to the parliament and to the government. So we have float appointment formula for judges. We have now this poisoned formula appointing judges, because it is involving the National Council of Judiciary. Probably you know that, but I will shortly say that the previous term of the proper council have been illegally shortened, and then politicians appointed judges for the new council. Of course, those judges that approved the idea of subordinating judiciary to the politicians. And this was the aim of subordinate judiciary and to follow the political will. So it was, of course, found as a violation of the tripartite of powers according to the constitution, and the judiciary was opposite. But we have the results of that, and one of the results is the judges that have been appointed in this poisoned proceedings. We now have the decision of the Supreme Court, 3 chambers of the Supreme Court. I don't know many judgments given by 80 judges of the Supreme Court same time from 3 panels. We did that in January 2000. and it was about the standard of being independent, this was a way answer for this assault of judicial independence. As a result, when in the light of a defective appointment of a judge, new circumstances appear or new facts appear, adjudicating that the concrete judge is not impartial and is not independent, we overrule his judgments and we annul its judgments. So that this is a huge problem in the legal system when the Supreme Court cassate the judgments of the second instance courts, but sometimes we do that. Last week we did that in few cases. I was in 3 cases by myself. We have to cassate the judgments because they have been delivered in 2000, 2001, 2002 by judges that were cooperating with the Ministry of Justice in the time when he was trying to subordinate judiciary to the government, the Ministry of Justice mostly. So this is a huge problem, and of course it opens the need to find a method of vetting judges and appointing new judges without this poisonous effect, if I may say. So and this is a complicated block of problems here. The next 2 problems are more dedicated to the problems that we face with the modernity. I would say that we have, as a Supreme Court, a problem with electronization of proceedings and computerization. We have very old-fashioned system of circulating of acts and documents and system of using communication tools. We have, I would say, old-fashioned and inadequate system of using electronic means of communication. We do discuss a lot how to do that, how to be like Estonia or Latvia. They are very fluent in this field. We unfortunately are not. We are discussing this for more than a decade. I remember that 15 years ago I was doing a research about the electronic communication in criminal proceedings, and the ideas that we had then have not been introduced since now. So you see, we are very ineffective, and it influenced the Supreme Court work. And the last point is the problem with the criminal law reform. The criminal law, substantial law, and the proceedings have been changed in the last 8 years many times. This is not only the stability, but the direction of those changes. We need a deep reform to withdraw from many of those reforms. For now, for this year, for this step, we will try to impose only some remedial law withdraw the biggest mistakes. We call that remedial act. So what it would be? It should be from the substantial law, mostly reduction of penalties in the penal code and rationalization of imposing penalties. This is very this is very populist. The last changes were totally populistic. For example, for the false assignment on the document, you can receive not less than 5 years of imprisonment. You can't get less. So this is very sick, but this is a situation that we have now. We have these penalties raised over the common sense of understanding. And from the criminal proceedings, we have similar problems, some reduction of formalism, and of course, reduction of extensively strong position of the prosecutor from last year's in the proceedings, in a way that the prosecutor was able to stop decisions of the court or would decide, in fact, on the court's decision, on judges' decisions. And of course, at the same time, implementation of EU directives, next week we will present that there will be presented the propositions about concerning the right to counsel for the accused, and to change this law is of course a huge problem. Now it's very unstable, and we face these problems in our everyday jurisdiction all the time. So this is something that takes a lot of time and makes many problems with efficiency of the everyday Supreme Court activities. Sorry if I was speaking for too long, but these are those 5 pillars that I would mention here. Thank you very much.
Thank you very much for this outline of the main problems of the current Polish Supreme Court. For those who do not follow the situation with our court, I would like just to add that the strong thesis of the speech by Paweł, I think, are certainly not exaggerated. The problems, especially related to the new judges, are very serious, and we treat them seriously. They make, and we can assume that our Supreme Court does not meet some basic European standards for an independent court, and this is a huge problem, of course, concerning only some chambers or some judges, but anyway, it's still the whole institution. So thank you very much, and now I'd like to invite Anna Adamska-Galant to take the floor. Thank you very much for joining us. We do not have the possibility to meet in person, but therefore it's really a pleasure to have you among us. And the presentation will be on the independent judiciary as a prerequisite of EU membership of Ukraine. So the problem that is also important for the Polish Supreme Court, I mean those EU standards that we should meet. So Anna, the floor is yours.
Thank you very much, Professor Florczak-Wątor. Thank you very much, Professor Trykhlib, for invitation. It's really an honor to be here with you and participate in this very important project. And actually, yeah, definitely there is a lot to be learned from each other, from Ukraine, from Poland, to both sides. And I have this opportunity to work in Ukraine since 2018. So it's quite a long time where I've been deeply involved in the judicial reform in the country. So I also have my observations. And during these last years of my work with colleagues from Ukraine, I was also trying to share these negative lessons from Poland, because actually restoring rule of law, what we are doing now in Poland, or at least trying, is definitely more challenging than developing the rule of law as Ukraine is doing. And as we all know, Ukraine received the status of the candidate state for the membership of the European Union, which means that Ukraine, same as Poland years ago, has to meet the so-called Copenhagen criteria connected with the rule of law, with the human rights. And this also involves stable, effective institutions that guarantee democracy, the rule of law, human rights. And like a crucial element of this is the independence of courts. And the project that I am working for, the EU Prawo Justice project, this is the biggest European Union project helping Ukraine on this EU path to prepare to meet the requirements and all these the requirements that are imposed. And of course, very important element, this is also European Union-Ukraine Agreement Association, where once again there is this reference to the rule of law in this agreement, the rule of law and respect for human rights as preconditions for membership of Ukraine in the European Union. And actually what we have been observing, and it has been mentioned by Judge Professor Antsupova, the judicial reform in Ukraine is lasting like the last phase. Okay, there were different phases of the judicial reform, but very important, it started in 2016. It was the result of the revolution of dignity, where there was a need for Ukrainian judiciary to be restored, to be built as independent, and also to gain trust of the society. Because this is one of the, I would say, biggest challenges of Ukrainian judiciary. So this low level of trust, which is a result of various factors, including, of course, unfortunately, corruption and the scandal that we faced like a year ago, which kind of undermine the trust. But nevertheless, what I see very interesting to follow or to learn from Ukraine, it is the way of selection of judges. And for me, it was very inspiring to observe the process of selection of judges of the Supreme Court in Ukraine and comparing it to the latest, let's say, selection of judges of the Supreme Court in Poland. Because the process in which also Judge Antsupova was selected, it was really very competitive. It was very complex procedure that lasted almost a year, that was combined from various stages, like verifying legal knowledge, like verifying integrity, like psychological testing. There was also a lot of transparency in this process because candidates who were applying for a position of judges of the Supreme Court, they had to go through public interview, the public interview that was conducted by the High Qualification Commission, supported by so-called Public Integrity Council. Public Integrity Council, this is also like original, I would say, development of Ukrainian system, because the Public Integrity Council, this is the council composed of representatives of non-governmental organizations who are involved in promotion the rule of law, independence of judiciary, etc. And they concentrate on delivering, on vetting of judges, on delivering like opinions about whether judges meet the criteria to be the integrity criteria, which are extremely important everywhere, but in the context of Ukraine, particularly because of this risk of corruption and also the questions that appeared in the context of decisions taken by the judiciary during the revolution of dignity, where unfortunately there were some judges who kind of compromised themselves. So this competitive, transparent and merit-based process of selection of judges of the Supreme Court is definitely something to be followed, something to be used. I'm not saying that everything was perfect. There are also a lot of concerns about the quality of the selection. However, it is like a step, like a very important step forward to build independent and effective judiciary. And Ukraine has gone, I would say, even farther when it comes to the integrity issue of judges of various courts or members of various bodies involved in the judicial system. Professor Wiliński, he mentioned the commission that Professor Suchocka is taking part in. This is the Committee of International Experts, or the Committee of Experts, that is involved in the process of selection of candidates for judges of the Constitutional Court. And this commission that Professor Suchocka is participating is a kind of a, I would say, standard model already adopted in Ukraine. Because in Ukraine, like 2 years ago, it was actually in the middle of this first phase of the war in 2022, the process of vetting High Council of Justice was organized. Because as we know, the High Council of Justice that is playing the similar role as the High Council of Justice in Poland is like the core institution in the system, because this is the institution that is responsible for selection of judges, promotion of judges, disciplinary proceedings against judges. So this is very important that members of the High Council of Justice are people who are meeting the highest standards of integrity and professionalism. So it was the reform that was implemented already in Ukraine, and that provided that all members of the High Council of Justice had to go through kind of vetting. The vetting was conducted by so-called Ethic Council, and this Ethic Council was composed from 3 members, like international experts, and 3 judges, 3 members appointed by the Council of Judges of Ukraine. So it was this mixed body, international Ukrainian, who was involved in the process of vetting of members of the High Council of Justice. And what is interesting, when this procedure started, when it was adopted, actually, as far as I remember, 11 members of the High Council of Justice, they just resigned because they didn't want to go through this vetting procedure. We can presume that they were just afraid of the result of this procedure. But then there was this competition. There were candidates running for the position of members of the High Council of Justice, and all of them had to go through this vetting that has been conducted by the Ethics Council. And also, what is important, the civil society, which is very active in Ukraine, was involved in this process because they are able to deliver information to the Ethics Council. It's not their role is not only limited to being like a watchdog. Their role is definitely more important because they provide with the information, they help to evaluate. And similar bodies, these kind of combined, like international with Ukrainian, were also formed to select the candidates for the High Qualification Commission for judges. It was this time the selection commission which selected candidates for the position in the High Qualification Commission. Once again, there were 3 members from international community and 3 members appointed by judges. And the idea of all these activities with the involvement of international community is to help our Ukrainian partners to build the system of judicial self-governance, which will be composed from people meeting highest standards, moral standards, highest professional standards, because only such people will be able to select judges who are like them, like judges with integrity, professional, and meeting all the standards. What is also an interesting lesson from Ukraine, I would say, I used to be a judge, as you have mentioned, and I used to be a judge 11 years in Poland. I was very active when it comes to judicial activism, like protecting judicial independence. I was a member of National Board of Justitia years ago. So when we were also fighting for judicial independence, because it's always the time, or it is always the case. But we were also fighting for a lot of judicial self-governance. And when I'm following the situation in Ukraine, I have doubts if Ukraine has not gone too far with judicial self-governance, because there is just the example for me, I would say that it was kind of shocking when I learned that it worked this way. When Ukraine formed a new high anti-corruption court, it is the assembly of judges of this court to decide on what date the court starts its operation. So it's not like in Poland, for example, that we have the law that on the basis of which the court is formed and the court starts operation. This is the decision of the Assembly of Judges. Assemblies of judges, they select presidents of courts. And on one side, it's a positive issue, but on the other side, this also brings problems because there are some competing interests. And in Ukraine, a problem is that there are very small courts. Like a court with 15 judges is already like a big one. So you have a court with 5 judges, and they are to elect among themselves the president of the court. Is kind of tricky. So Judge Professor Antsupova, she mentioned this closed cycle of judiciary. So this kind of, I would say, corporationism. I'm not sure if I pronounce it properly, but this is like a serious risk. And what I think that we can see this corporationism in all these bodies that have been formed. So of course, the High Council of Justice, majority of judges, but this model of majority of judges has been transferred to all these Ethics Council, High Qualification Commission, and other bodies that are involved in promotion and promotion and selection of judges. And this risk of judicial corporationism is real, and I think that we can observe it in Ukraine. And actually, when we follow the discussion that is even on let's say European level, whether this model of the High Council of Justice with majority of judges is a proper one. So I think that the example of Ukraine can serve as an interesting illustration of all the risks that are connected with this such a model. And what I don't have kind of a clear, how to say, view on this. But when we think about the High Council of Justice as the body that is to protect the independence of the judiciary, actually it should protect the independence of the judiciary against all the powers, judicial, executive, and legislative. And this is a question how to balance, and also how to involve the civil society perhaps into the system. Because as I said, in Ukraine, civil society organizations are quite deeply involved in the processes of reforming the judicial system, selecting of judges. But the question is how it should be, or whether it should be kind of institutionalized, because this is also a question of accountability. So to sum up my kind of perhaps little chaotic presentation, I think there is a lot that both sides can learn from each other. We from colleagues from Ukraine, Ukraine from us. But what I really want to underline that the importance of these kind of meetings, as you both professors, you are doing, that you are bringing together lawyers from Ukraine, lawyers from Poland to exchange the ideas, to discuss, and to build these links between Poland and Ukraine, because we are very close to each other. Thank you very much.
Thank you very much for this great speech, and I think it confirms our strong conviction that we have with Kristina when we started this project, namely that what is common for both countries, Poland and Ukraine, is to remain halfway in the relation to the European Union, but the main difference is that Poland is halfway leaving the European Union, while Ukraine is halfway heading towards the European Union. So in both cases, in order to get closer to European standards, we need deep reform concerning our courts, our judicial system. And the other similarities is that was mentioned in the presentation, that in both countries we can count on the strong support from the civil society, and the citizens are a strong factor in supporting the good reform, hopefully, that will be also in both countries. Thank you very much. And last but not least, Marcin Szwed, I would like to also invite, as I said, Marcin is not only the scholar from the University of Warsaw, but he's also a lawyer from one of the biggest NGO in Poland. I mean, the Helsiński Foundation for Human Rights. So Marcin, the floor is yours.
Thank you very much for inviting me. I will try to present you in my short presentation the different forms of NGO activities during the rule of law crisis, sharing also some reflections on their significance and effectiveness. Of course, I am not fully impartial in this regard because I'm a lawyer at one of these NGOs. However, I will try to be as objective as possible, and I promise that I will not focus only on my organization, but also on achievements of other civil society organizations. Before I move into the main topic of my presentation, I'd like to briefly recall how Law and Justice attacked the Supreme Court and attacked the judiciary as a whole. So the first attack targeted the Constitutional Tribunal and subsequently other judicial bodies, especially the Supreme Court. In 2017, PiS attempted to reorganize the Supreme Court by passing a new law. However, this attempt failed because the president exercised his right to veto, because he believed that he argued that this law gave too much power to the prosecutor general. However, a few months later, the parliament adopted, upon the president's initiative, another law on the Supreme Court, which in essence differed little from the vetoed one. And the new law included, among others, the internal restructuring of the Supreme Court by creating two new chambers, the infamous disciplinary chamber and the chamber of extraordinary control and public affairs. The more controversial was the first one, the disciplinary chamber. It was perceived as a tool to harass, to curtail the independence of judiciary, and it was also composed of judges who had strong links to the executive power, especially Minister of Justice. Moreover, a new extraordinary complaint mechanism was introduced, which, as it was feared, would be used to politically challenge final judgments, even those issued many years ago. Additionally, the law also lowered the retirement age of Supreme Court judges to 65 years, and this new lowered retirement age was to be applicable also to judges who are currently sitting at the Supreme Court. However, eventually this change was withdrawn after the judgment of the Court of Justice of the European Union. In addition to these legal changes, personal changes were also significant. Professor Wiliński already mentioned that this new process of appointment of judges, and since 2018, already around 60 judges of the Supreme Court, that is the majority of its composition, were appointed in this unlawful procedure upon the motion of unconstitutionally composed National Council Judiciary, and moreover, serving first president of the Supreme Court was also appointed in this procedure. This was found to be inconsistent with European Convention on Human Rights and the EU law in a series of rulings, both of Polish courts and international courts. Peace attacks on the judiciary also took the form of abusing disciplinary and even sometimes criminal procedures against judges. The best-known cases concern common court judges like Judge Juszczyszyn or Tuleya. However, in the context of Supreme Court, it is worth to note the case of Judge Włodzimierz Wróbel, against whom the prosecutor filed a motion to lift immunity under very dubious circumstances. And all these attacks on the independence of the judiciary, including the Supreme Court, met with reaction from Polish NGOs, and many organizations of various profiles and specialization took part in defending, of course. First and foremost, attention should be paid to the role of judicial associations, and the largest of them are Justitia, and then secondly, Temis. Both this organization unequivocally condemned peace actions in the area of justice. They even called for the boycott of the procedures before the unconstitutionally composed NCJ. And generally, these independent associations strongly resisted against the limitations and violations of the judicial independence. Existing human rights NGOs have also been involved in the defending for the courts. Here, attention should be paid to my organization, Helsiński Foundation, which is the largest and the oldest human rights NGO in Poland, which had a long history of actions aimed at protection of the access to independent courts. Other organizations such as Polish Amnesty International, Organization Forum for Civic Development, or Stefan Batory Foundation with its team of legal experts also drew attention to the threats associated with attacks on the judiciary. However, all these organizations have a more general profile, and protecting the independence was just of judiciary was only a fragment of their much broader activities. The scale of attacks on the judiciary, therefore, necessitated the creation of new initiatives strictly aimed at defending of courts. This is how the organization Free Courts was established, firstly in 2017 as a citizen initiative, and then in 2020 as a foundation. Moreover, in order to ensure cooperation between these various organizations involved in defense of independence of judiciary, the Committee of Defense of Justice was established in 2018. In addition to these organizations which focused on some legal actions like taking cases to courts, both Polish and international courts, also civil organizations conducting social campaign or organizing public assemblies contributed to defense of independence of judiciary. And these include, for example, the Committee for the Defense of Democracy, Social Movement Citizens of Poland, or the Foundation Action Democracy. And all these NGOs fought for the protection of judicial independence through various means. Firstly, NGOs were involved in the organization of public assemblies in protest against changes in the judiciary. And the largest of such protests concerned attacks on the independence of the Supreme Court. In July 2017, protests took place in many cities in Poland against the new law on the Supreme Court passed by the Sejm. In this atmosphere of protest, the president vetoed the law, Although, as I have already mentioned, this success turned out to be only apparent because just a few months later, a new law was passed, which was as harmful as the vetoed one. Subsequent protests took place in November 2017 when the second law was passed, and then many protests were also organized in summer 2018 when, due to the lowering of the retirement age of Supreme Court judges, the first president of the Supreme Court, Professor Gersdorf, was to retire before the end of her term of office as the first president. The organization heavily involved in organizing these protests were Action Democracy, Committee for the Defense of Democracy, Citizens of Poland, and also the above-mentioned three courts. NGOs also prepared a number of professional legal opinions on the draft laws violating the rule of law standards. During the legislative work on the laws on the Supreme Court, such legal opinions were presented, among others, by the Helsiński Foundation, Justitia, or Stefan Batory Foundation, and all these opinions were, of course, very professional, and they raised serious issues in terms of compliance of these bills with constitutional and international standards of judicial independence. Organizations also prepared reports on the situation in the judiciary and attacks on the independence of judges. For example, the Helsiński Foundation published reports on the legal changes in the Supreme Court between 2017 and 2021. Meanwhile, Justitia prepared an extensive report, which was updated a few times from that time, on the repression against independent judges. And all these actions were more related to advocacy, and advocacy actions also included, for example, informational campaigns, promotional videos, and so on. However, Polish NGOs also used litigation measures and were involved in various proceedings before courts. So, for example, some organizations submitted amicus curiae opinions in cases concerning the protection of judicial independence, especially those pending before the ECHR, because, as you may be aware, the rules of Court of Justice of the European Union exclude the possibility of filing amicus curiae. So it is impossible to file amicus curiae to proceeding before EU courts. Among Polish NGOs which submitted amicus curiae opinions, the Helsiński Foundation in particular stands out. So we in our organization submitted opinions not only in all the most important Polish cases before the Strasbourg Court, but also cases concerning other countries which, in our view, had some significance for the situation in Poland, such as the case Astrason versus Iceland, which concerned this unlawful judicial appointments. Of course, we were not the only one organization involved in such actions. Also, Justitia submitted a number of amicus curiae opinions. Litigation activities of Polish NGOs were not limited only to amicus curiae opinions, but also included directly conducting cases before courts. Such proceedings were conducted, among others, by Helsiński Foundation. Of course, we are more of a general NGO, human rights NGO, and we deal with many different matters. There are many different problems with human rights in Poland. Therefore, we have to focus only on a small number of cases, which, in our opinion, had some potential for landmark verdicts in Strasbourg. For example, we litigated the case of Judge Juszczyszyn, who was suspended by unlawfully composed disciplinary chamber of the Supreme Court, and this judgment led to, we can say, a precedent ruling, because it was the first judgment in which the European Court of Human Rights ruled that Poland violated Article 18 of the Convention. So this meant that Poland violated the right of independent judge in bad faith. Moreover, at the moment, we represent another judge suspended by the Minister of Justice for 30 days, Judge Mickiewicz, and this case also had a potential for some landmark ruling, because the European Court will have opportunity to rule whether Article 6 provides to every judge in Europe a subjective right to have his or her independence protected and respected by state authorities. More litigation before Polish and international courts was conducted by lawyers from Free Courts organization, which specialize in proceedings concerning threats to judicial independence. At the national level, lawyers of this organization represented judges who were wrongly accused of unethical or unlawful conduct in proceedings before disciplinary chamber and chamber of professional responsibility, which was established after the abolition of the disciplinary chamber. At the international level, they were involved in many groundbreaking proceedings before European Court of Human Rights and European Court of Justice. As for the former, they, for example, represented applicant in the case Dolińska, Ficek, and Ozimek, where the European Court held that judges of this new extraordinary control in public affairs chamber were appointed with violation of law, what leads to violation of Article 6 of the Convention. Moreover, great success of this lawyers from free courts was the case of Judge Wrubal, and this was success because it was the first case in which the European Court of Human Rights issued an interim measure concerning the independent judge. So in the past, the European Court usually refused the applications for interim measures in such cases, believing that these cases do not involve the risk of irreparable harm. However, in this case, the European Court changed its approach. So a very important ruling, although the final judgment has not been delivered yet, but the decision of interim measure was very important. As for the involvement of free courts in proceedings before the CJEU, one can mention, for example, the case of AK, which was the first judgment of the European Court concerning the crisis around the Polish National Council of Judiciary. It is worth noting that the dynamic development of the rule of law standards in the case of the Court of Justice of the European Union was possible precisely because of preliminary references made by Polish courts. And in this regard, it is worth noting that already in 2017 and 2018, Helsiński Foundation conducted a series of trainings for Polish lawyers and judges on formulating preliminary questions in the field of human rights law. We also published handbooks on this topic and a report on the role of Court of Justice in protection of human rights. Moreover, Polish NGOs, of course, also monitored the implementation, or rather lack of implementation, of the execution of judgments of European courts, for example, through correspondence with Committee of Ministers of the Council of Europe. Therefore, Polish organizations, as you can see, actively work to protect independence of judiciary, including the Supreme Court, using various tools. However, to conclude, it is also worth to note, to analyze whether ultimately such actions were effective. Did they change anything? And looking at the current situation in the Supreme Court, one might get the impression that these actions were rather futile, because the Supreme Court as an institution is immersed in deep crisis, and its authority has significantly declined. And one of the best examples of such crisis, of such chaos, is the fact that quite recently the Supreme Court issued two contradictory judgments in the case concerning termination of mandates of deputies. One of the ruling issued by lawfully appointed judges, and second by those appointed unlawfully. And therefore, this shows that the situation is very difficult in the Supreme Court. However, such an assessment of the role of NGOs would be too superficial, because it is clear and obvious that NGOs are not able to completely stop the actions of legislative and executive branches of power, because they do not have any power to do this, especially in a country which don't even have an independent and effective constitutional court. Nevertheless, it would be unjust to trivialize the activities of NGOs. Firstly, NGOs' actions contributed to raising awareness among Polish society about how essential the rule of law and judicial independence are. And it is no coincidence that in the political campaign prior to the 2023 parliamentary election, the restoration of the judicial independence and the rule of law were one of the main topics, and also one of the main electoral promises of the new ruling coalition was to implement judgments of European courts and to restore the rule of law in Poland. Secondly, although the current situation in the Supreme Court is indeed very bad, it cannot be ruled out that without actions of Polish NGOs, this situation could be even worse. For example, eventually, there were no massive removal of Polish judges, and judges were suspended, were eventually reinstated. Moreover, the disciplinary chamber was suspended for some time, basically, and ultimately it was abolished and replaced by new chamber, which is also controversial. Nevertheless, it less frequently blatantly violates the independence of judges. Thirdly, it was thanks in a part of the actions of Polish NGOs that the rule of law crisis was not only perceived as a Polish internal internal matter, but also became a European problem. The ECTHR and Court of Justice European Union issued many more rulings on the crisis in Poland, for example, in Hungary, where this illiberal democracy has been built for even a longer time. And all these complaints of Polish judges, amicus curiae of Polish organizations, contributed to development of pan-European standards of judicial independence. And finally, although during the Law and Justice government, this rule of law standards, international standards, were largely ignored, and the judgments of European courts were not implemented. Currently, these judgments serve as a starting point for the rebuilding of the rule of law in Poland, and NGOs also play a significant role in discussion in this process by presenting their draft laws, opinions, and reports. And although it is already evident that there are sometimes significant differences between various organizations engaged in the actions for the rule of law regarding the means by which this judiciary should be repaired, such differences in views should be considered as a normal and even desirable in any healthy democracy. Thank you very much.
Thank you. Thank you very much. Can you hear me?
Yes, we can.
Thank you. So, dear Monica, dear speakers, thank you very much for your really very meaningful and interesting presentations, and also for your kind words of support. Now I would like to open the discussion. So, dear audience, please feel free to ask any questions, give comments, or maybe express your own point of view. So you're very welcome. I think that we will first collect questions and then give each speaker an opportunity to respond to them. If we don't have, always a problem is, we have one. Please, Camilla, you're welcome.
Yeah, first of all, thank you very much for your wonderful presentations. It was incredibly informative, especially in light of our smaller research projects. And I have a question for Tetyana Alexandrovna and Anya Adamska-Gaunt specifically, but anyone can answer on it. And so, returning to the question itself, you mentioned that one particular scandalous case concerning corruption played a very big part in the issue of trust in the court. And this is actually a good mention because I want to ask you, whether you think that Ukraine's information policy is a little bit unsuccessful in portraying the court in the media. Like people like drama, people love drama, and people's brains remember negative fragments better. So articles like the court unfairly found someone guilty or someone managed to avoid a fair punishment and so on go viral better than those in which the court is doing much better job. And do you think that we should also be more active in the media in promoting trust in the courts? For example, to show more positive legal characters connected with the court in national TV series, because reforms is reforms, yes, they are good. But if our information policy continues to support social stigmas about the court, like the court is bad, the court is corrupted, because it is easier to reach a larger audience, it will be incredibly difficult for the public to achieve any really big result in trust in a court, won't it?
Thank you, Camilla. I would like to comment that Camilla is one of our students who is also involved in our project. So they work in pairs. I mean, Ukrainian students and Polish students, and they are conducting their comparative research. Feel free to ask also our dear students. Don't be shy. If you have any questions, you have a unique opportunity to ask your question from the first, I would say, subject who are delivering justice in practice. So thank you. Any other points, comments, questions? Yeah, we have one. Dear Igor Shevakov, please, you're welcome.
Thank you. Good evening, ladies and gentlemen. You told my name. I'm an administrative court in Poltava region, Ukraine, and I extremely support the question of previous colleague about the politics of Polish judges in sense of their in sense of information in media about them. Do you have a kind of information strategy, a kind of information politics, so on? And the question I wanted to ask is close. In Ukraine, we are looking forward to your next victories in your struggle for judges' independence. And Polish colleagues are a kind of example for us. I mean, your story with Supreme Court and so on. We all know what we are talking about. And the question is, did you do something special to involve society in your struggle? Because we see that a kind of controversial Polish judicial reform was detached with some social scandals. We saw a crowd on your streets and so on. Was it accidentally, or it was kind of maybe a judge's strategy? You know what I mean. Thank you.
Thank you, dear Igor. And we have also questions from Justice Pirkov. Dear Justice, maybe you could, I see you wrote it, but maybe you would like to or should I read it, or would like to ask this question personally? I can read. Okay. We have a question from Justice Pirkov from Grand Chamber of the Supreme Court of Ukraine. In your opinion, and according to your assessment of the Polish society, does the general public, the society in general, understand the value of an independent court? Or is public dissatisfaction with government's assault on judicial independence more a manifestation of general dissatisfaction with government policy? In other words, would the public defend judicial independence against a government that has voter support in general? I understand that a government that has the confidence of its citizens will typically respect the independence of the judiciary, but still. So I think that we could, I would like to give voice to our speakers, and then we will continue the second round of questions.
Yes, if I might add to that, indeed, that question is about the general perception of the importance of independence of the judiciary, because in Ukraine, even among prominent lawyers, we have these conflicting tendencies of putting judges under the press of accountability. Let's make them accountable. Let's control every action they take. And on the other hand, the declaration of the importance of the independence. In some cases, those theses contradict each other because sometimes the accountability is understood as creating some super instance over the judiciary, and in some cases even lawyers tend to grant that moral authority to some higher power, for example, the head of the state. So my question is whether it is the same in Poland, and whether the public protests that the Poland has the experience of dealing with was exactly about the judicial independence, or was it more the manifestation of the general dissatisfaction with the policies of the government? Thank you. Thank you.
Thank you very much. As I said, maybe our speakers will answer these questions, and then we will continue the second round. So who wants to be the first?
I can be the first if you want.
Okay, you're welcome.
Yeah, so very difficult question and very interesting one. Probably to fully answer to this question, we have to make some very big sociological analysis and survey. Nevertheless, in my opinion, if we make such a survey, probably many people, majority of people, vast majority, will reply that, of course, judicial independence is very important. However, so probably Polish society believe that we have to respect judicial independence, and I think that this massive protests that were organized in 2017 and later were not only because of dissatisfaction with the governments, but also with the actual feelings that people were actually worried about what was going on in Poland, and it is also, in my opinion, important that these protests were organized, for example, in 2017 and not in 2015 when the first attack on the Constitutional Tribunal happened. Why only in 2017? Because probably people needed some time to understand the importance of the rule of law and judicial independence. So generally, I believe that Polish society understands the importance of judicial independence. However, I think that we also have to keep in mind that right now the trust of Polish society into the judiciary is also very low. So when people get some judgment which they feel is unfair for them, they might have some doubts as to whether the judge who gave the decision in their case is fully independent or fully impartial. As I told you, we had 2,500 judges were appointed with violation of law, and people may legitimately doubt as to whether these people are fully independent or not. Moreover, even before the constitutional crisis in Poland, the assessment of the general satisfaction of Polish society with courts was very low. I think it's like, I think around less than 40% of people believe that Polish courts functioned properly. So in my opinion, even though people may declare that courts should be independent, they also believe that there's some changes in the organization of judiciary must be done in order to ensure the proper functioning of courts. But I wouldn't say that people expect that judges are subject to some more pressure from politicians. I believe that they expect that some big reforms are necessary to make courts more effective, for example, to eliminate the excessive length of proceedings. But I think that this opposition of Polish society against these unconstitutional reforms of peace were rather honest, and this was not only a symptom of a protest against general policy of law and justice.
Thank you very much. Maybe Dr. Anna Adamska would like to add something.
To be honest, I would not be as optimistic as my predecessor, as Mr. Szwed, when it comes to the resilience of Polish society as such. First of all, it was a huge work of Polish judges, such NGOs as the one that Mr. Szwed is representing, to make people aware of, to make people understand what is going on with the judicial system. And to be honest, the fact that the governing party then was able so easily to take over, or at least to take control over the judicial system to a certain extent, it was a result of this lack of understanding from the Polish society. So these last 8 years, I think that Polish judges, Polish lawyers, various professions, they used really well to make people better understand why the judicial system, independent judicial system, is important. And I think that what was really relevant, it was in the end the election we had in the autumn last year, where so many people voted against the previous governing party. So, but it took time, and this need for education is like an ongoing. And I know that colleagues from Poland, from Judicial Association, other legal association, let's say, that we are continuing this work to make people aware of the importance. So this is what needs to be underlined, that this working on education, on awareness of the people of the importance of judicial independence needs to be continued. It takes time, but it needs to be continued. I also like to return to the first question that was put by I think Pani, the student. I forgot the name. I absolutely agree that Kamila, I think, yeah, I absolutely agree that when we read about Ukrainian judiciary in the media, we mainly read negative messages, negative messages about corruption, about judges without integrity, etc. And I think that this is like a false image of the Ukrainian judiciary. I have been traveling a lot in Ukraine, visiting many courts, working with many judges, with many people from small courts, from big courts all over Ukraine. And there are a lot of good people, but these positive messages, it's much more difficult to transmit to the society. And actually, it's like a kind of a vicious cycle, because if you always read negative messages about the judicial system, you will never trust it. So this is really very important that judiciary in Ukraine is also able to build like a positive image of this what is happening, and it can be done on various way. And I know that colleagues from Ukraine, they are extremely active when it comes to the social media. I think I haven't seen so active judges in the social media as in Ukraine. On the other hand, there are so many initiatives, and I will tell about my initiative from my project that is called Model Court Initiative, where we started with 6 courts like 5 years ago, who were appointed to join the project to promote good practices in courts. And now we work with more than 90 courts from all over Ukraine who are trying to improve the communication with the society, the services for the society, and to change like perception of the court, not like a place of power, but rather like a place of service also for the community. So this is like a work that is being done, and this is very important to have balance, because if we concentrate only on negative events, we will never have trust into the judiciary, because there will be always this perception that everybody is corrupted and everything is wrong, and this is not true. I really believe that huge progress has been made.
Thank you. May I please join reflection to the first question? And I would like to thank Anna for that work which she is doing and representing what's going on in Ukraine and witnessing actually what is going on and giving all of these feedbacks and opinions, which is very important for the international partners and stakeholders and etc. So I would like to support what Anna said, and I would like to add that communication policy of the courts and Supreme Court in particular is very important, and it makes the work of court visible, and but it should be systemic and structured, including the crisis communication, because it is a special sphere of communication. And I think there are, and Anna absolutely right, that there are different ways and different solutions how it may be resolved, how to up the game, so to speak, and how to represent to society what work has been done and what is the face of the judiciary, the true face. And I think that communications through mass media are important. We know that there are some rules for communication with society, and in particular, they've been systematized in Consultative Council of European Judges opinion number 25. I think everybody seen it, concerning the freedom of speech of judges. So in my point of view, what could be done, I think the role of speaker judges could be increased, and to put it in systemic way, to put it in the way when judges are not afraid to communicate to society when the high-profile case was considered or the scandal was happened. So it's all, step by step, very careful work. But I think we can do it. I think, as I said, we can up our game. Thank you.
Thank you very much. And dear Paweł, you're welcome.
Yes, thank you. Speaking and being fifth in the line is usually nice because most of words you wanted to say have already been said. But I want to share with you the experience of a person that in 2015 was not a judge and were observing the beginning of this fighting against independence of judiciary. At that time I was working in the Constitutional Court. And most of Polish, they didn't believe that anything that bad will happen. Some were saying, we have to protest now because then there will be too late. There will be no Constitutional Court, there will be no independency, there will be no National Council for Judiciary. Some were saying that, but the rest were saying, oh no, they will never touch us. I remember judges of the Supreme Court that time saying they will never dare to touch the Supreme Court. They will never dare to touch this or that. And when these changes and quasi-reforms came, it was too late to protest. Judges are not very popular in Poland, but we have to understand that they're usually not very popular. We do not give satisfaction to people because at least 50% of them lose their cases. It cannot be differently. If you have to give the verdict, it is always at least 50% that will be dissatisfied. And usually it is even more. So I don't look at this that people should love us, but people should understand that we give them at least independence, that when we decide, it will be independent. And how we should give this information to society. We judges were used for years that we do not communicate to society other ways that through our verdicts. It was a society rule that we do not speak publicly, that we do not communicate to the publicity, that we not discuss that decisions. Only spokesman gives this information, that we do not educate society. If you have a chance to educate society, you have a chance to do something good. So my advice would be for Ukraine, start educating society as much as you can, not counting on that they will change their minds always, but they will understand what's independence. Maybe they will not defend judges, but they maybe will defend independence of judiciary. Thank you.
Thank you very much. Yeah, so any other questions? Please, Tetyana Ognivyuk, please.
Good afternoon, dear colleagues. First of all, I want to thank our great lectors. It was very interesting for me to know the problems of Polish judiciary. And I see that we have the same problems. Our second, I suppose, speaker, colleague from Poland, Paweł, told about how the state often appeals court decisions all the way to the highest level. And we have the same problem, even when the decisions of the authorities are clearly unlawful, they are appealed to the very end. What can be done with this? How do you say? And how can we fix this practice? Because it seems like a waste of public funds and shows a lack of trust from state to state courts. Maybe for courts of first or second instance, I don't know what is the reason of such practice. So, Paweł.
Thank you very much. Thank you.
Yes.
Thank you. Any
Thank
other
you.
questions?
Yes. Can I answer now? Or
you're welcome. You can answer and then.
That's a fascinating.
Yeah, you can answer. Yeah.
Thank you. It's a fascinating question, and I do agree that this is a universal question. It stands in Ukraine, it stands in Poland, and I believe it stands in every country. But here in Poland, this is a deep problem. the lack of faith in what the justice system is. This is like misunderstanding. Justice is something different than administration. Administration gives decisions, and this is a decision of the worker for administration. And I believe that society don't understand the difference between giving decisions and appealing against decisions and delivering justice. I understand that this is a kind of our still communist tradition and the lack of long lasting tradition of fair trial standards and standards of independent judiciary. We have a tradition that we don't trust. It comes from our history. We don't trust the government, we don't trust the officials, and we don't trust judiciary. So if there is a possibility to appeal, we will appeal till the end. Even if there is no appeal, we will appeal against lack of appeal. I will give you the example that struck me years away. We had a student at the Faculty of Law in Poznań who went for holidays to United Kingdom, to London, and then he attacked a woman and he raped her, and finally she died. So he was get back to Poland, and then he was extradited to Great Britain, and then he was tried there. And the trial lasted for 3-4 months, and there was a verdict. He was sentenced twice for life imprisonment, with the condition that he can ask for permission to leave after 15 years, even if it was life sentence. And then he was sent to Poland to serve this sentence. His lawyers in England advised him that there is no chance for successful appeal. So he raised no appeal against this verdict, and it is finished after first instance to life sentence. So it was sent just to execute this penalty to Poland, and the procedure opened. In Poland, we had 6 rulings of the courts, first and second instance, how to execute that. Then we had a constitutional complaint to the Constitutional Court, which I remember was in my hands. Then we had 3 cassations in the Supreme Court about different small issues of this execution of this verdict. So I asked myself, what would happen if in Poland the counsel, the defense counsel, would say to his client, there is no chance, let's not raise an appeal in the verdict of the life imprisonment. I believe that he would be he would have to resign from his practice. And there it was okay, because it was following their tradition. To give the verdict, to finish the case, it was just 1 instance. In Poland, we had 10 or 12 instances to discuss all this. He did that in Poland because he knew that he can, and he can prolong that. He didn't do that in England because he knew that this is pointless. And the lawyers, the lawyers, the counsels, prosecutors, they understand this game. So they follow the game and follow the rules. In Poland, I believe, many lawyers know the rules, but they are not always going to follow them if they have any interest not to do so. Different kind of interest. I mean, also legal, like working for the client. So I don't know if this is a clear answer, but my answer would be, this is a universal problem of Ukraine, Poland for sure, and I believe many other countries that don't have a very long legal tradition, and the lawyers are not following this tradition for any reason. Thank you.
Thank you. Thank you. It was very interesting. And I agree with you. It's something like cultural aspects of problem have. Thank you.
Yeah, thank you very much, dear Paweł. I absolutely also agree with you, because for Ukraine, for Poland, we have common problems, and definitely the lack of legal culture, our common legal tradition, but also education, the lack of education, legal education, I mean the international standards with European human rights standards and so on. And all these matter when it comes to the rule of law. And we must identify these weak points. And our task is to strengthen, to develop these weak points. And of course, we see, unfortunately, we see the consequences. Any other questions or comments to this point? If not, I would like to ask questions. I have several questions, 2 questions for the judges and 2 for representatives of our NGOs.
I think I can have a question.
Our judges, how have you ever?
There
Sorry?
is one question. There is additional question.
Oh, can you hear me?
Timur. Yeah.
I think I'm not sure it's pretty relevant to the discussion, but I think it touches upon independence of judiciary. So I'm a PhD student at the Yaroslav Mudryi National Law University, and my topic is interpretation, authentic interpretation of laws, or by parliament, by other governmental bodies. And of course, it raises question about independence of judicial process. We all know that there are problems with consistency of judicial case law, for example, in Ukrainian Supreme Court practice. I think in Polish judicial system, it's always the case as well, when you have some contradictory legal positions, some matter, and this takes, it goes for a long time, legal uncertainty, and sometimes it's in some countries, for example, they are in minority, of course, there is a possibility of legislator or a lawmaker to interpret its own provision with retrospective power, for example, in Belgium. And my question number 1, of course, do you think it's permissible, it's justifiable to allow lawmaking body to interpret its laws and, for example, neutralize some judicial positions, which are going not in accordance with intent, or to resolve legal uncertainty, for example, when it's not clear what actual legal position is. So, and I'm more interested, of course, in opinions of Polish colleagues, especially judges. Is that a real big problem in Poland, for example, that lawyers cannot understand judicial positions, what is actual case law and contradiction between case law? And is it case in Poland that a lawmaker or other bodies, authors of law, so to say, can interpret, clarify, elucidate some law or some provision of law, and either any judicial deference to this? How do judges react to such interpretation? Because in Ukraine, we have no idea. I think there is no theory about it. There is no practice for such things, even though we have some recommendatory parliamentary interpretations. Some committees of Ukrainian parliament can interpret laws, or some watchdogs or some ministry, but there is no theory about it. There is no understanding of the power of such interpretations. And of course, how does it interact? How does it affect the theory of separation of powers? To sum up, there should be judicial monopoly on the interpretation of laws, or other governmental bodies, especially lawmaker itself, can interpret, can resolve legal uncertainty, can neutralize some legal positions of judges which are wrong from the point of view of democratically elected parliament. Thank you so much. Thank you.
Thank you, dear Timur. Any other points, questions?
I've got one, if I may, Kristina.
Yeah, Monika, you're welcome.
Yeah, thanks a lot. Very short question, because there have been many questions in our discussion on so far about how to build or strengthen the authority of the Supreme Court in society. And you have already said about the education of civil society, that this is important, and also that good communication between judges and citizens is important. But I wonder if we should change something in the training of judges, or more generally in the training of lawyers, because we are not going to solve the problems within the judiciary just by educating society or communicating better some issues with the society. So what changes do you think should be made in the training of lawyers and judges in order to strengthen the authority of the judiciary in Poland and in Ukraine?
Thank you very much. Dear Justice Kristina Kowalik, you're welcome.
Yeah, hello. I wasn't intending to speak, but this discussion really steered my attention. First of all, congratulations to all of the speakers, and I think this dialogue between Ukrainian and Polish lawyers is very important, both for the future accession of Ukraine and for our perception of the situation in Ukraine. But I have a more general observation. As Professor Wiliński was mentioning, at some point I wasn't a judge and I was observing the work of the judge from outside. And I remember participating in a seminar with constitutional judges from Germany. And one of those judges said that judge in media is like a rabbit on the motorway. Usually judges are somewhere in the shadow, working on very complex issues with a lot of gray areas. So media environment is not something natural for judges where it has to be black or white. And you have to have a very short message that this is a good person, this is a bad person, and all is clear in a sense in the media. Whereas for a lawyer, for a judge, nothing is clear. And this is, I think, as well an educational problem that people don't understand it. People want a quick and very clear decision. But I think the Polish crisis during last 8 years forced the judges to fight for their independence by all accessible means. And I am very grateful as well to the NGOs and all the judges associations who were doing the job as well. But the judges were forced to somehow find a way to keep their independence and to maintain their status despite the actions of, despite the state action, yes, which is a rather unusual situation. So my general question would be not about the education of the judges, because you cannot really be prepared this type of situation as before, unless you are faced with this type of situation. You don't know how to react. But what could be the best way to somehow avoid this situation that the judge has to be its own advocate? Thank you.
Thank you very much. If there is no questions, I would like to ask my questions, and then I will give a floor to our speakers. So as I said, I have 2 questions. The first question is, have you ever encountered in your practice, I mean in judicial practice, the need to render judgments contra legem, or contrary to the law? That is, in a situation of obvious contradiction between the legal rules, the so-called letter of the law, and legal principles, the spirit of law? And if so, what methods of argumentation, reasoning were most applicable in such a case? And the second question, how do you assess the prospects and the possible existence of lawmaking elements in judicial practice, especially in the practice of higher courts, in particular in the Supreme Court of Ukraine and Poland? And how do you define for yourself the margin of appreciation, the boundaries of free judicial discretion, and let's say going beyond the so-called permissible limits of interpretation and the beginning of pure legal rulemaking? What criteria do you set for yourself in this regard? And my question to representatives of NGOs, how do you assess the readiness and willingness of government bodies and representatives of judicial self-government government bodies for truly fruitful cooperation that would bring the desired results in practice. First of all, in the context of a real strengthening of the principle of the rule of law and all its necessary elements. How can you describe this communication and relationship? Perhaps something could be improved, so how looks like this interaction? Thank you very much, and I would like to give the first floors to Professor Tetyana Antsupova, because I know that she must leave. So please, dear Tetyana, the floor is yours.
Yes, Kristina, thank you so much. And there are so many questions which are in different dimensions, and I would probably address to the last one, which you asked concerning the application of principles of law and rule of law, but not legal rulings as such. Yes, it happened in judicial praxis, of course. And of course, it is the most difficult way of how we motivate, how we put our motives into the motivation part of the judgment. But the best way to do it is the transparent way. So the judge shouldn't hide his or her approach and shouldn't hide the concerns and the real problems in consideration of the case. And I think the understanding of practice of the European Court of Human Rights really enriched the understanding of Ukrainian judges, what means to apply principles of law, what means to apply rule of law and spirit of law in case the decision of the administrative decision or the norm, the rulings is not in accordance with the spirit of law. And I can remember several such judgments when we applied such an approach, and I'm really grateful to my colleagues for supporting it. And I think this way, how the law develops and how the case law of the courts develops, when this is the room for courts to show their real role, how they can interpret not only the strict rules, but also how they can apply to the life situation, just general logic and general understanding of law. So I think that's the highest quality of judges who can do it. And thank you for your question. And of course, it may be a long discussion. Thanks so much. And unfortunately,
I realize. Thank you very much.
Yes, thank you, colleagues, so much.
Thank you very much. I realize.
For inviting me. And unfortunately, I should leave in a minute. So it was a pleasure for me to join. Thank you so much.
Thank you very much for being with us today, and we wish you good luck and see you very soon in Krakow, online. Yeah, but I mean during our next conference, final conference. So see you. Yeah, I realize that my questions they actually are quite broad, but very interesting. Thank you. And I think that Kristina would like to maybe add something or reflect, on what was said.
Professor Trykhlib, sorry, can I answer now, because I also have to leave? I should already leave.
Yeah, great. Yeah, of course.
Sorry.
You're welcome.
I'm sorry, but this meeting should last 1 hour and a half, and I was informed that not longer than 7, so I have the obligations to leave before next meeting at 8. I will try to answer shortly for a few questions. Each of them could be a reason for a long discussion, so it's not easy to answer them very shortly. But the first question was about interpretation of law and the lawmakers. can they clarify the law? Well, of course, they love to clarify the law. Politicians always knows better. They always, everything knows better. And they think that they know law better because they vote about the law. So we know that there is something in Polish theory of law, like official interpretation of the law or original interpretation. This comes from from the person who give the law. But except that, and more important, this is not really binding. But the binding interpretation comes from linguistic interpretation, systematic interpretation, or we also say guarantee interpretation of law. And this cannot come from the politicians, cannot come from the government. And they don't like these situations. In Poland, they try to solve situation this way, that they change the law. If they don't like the line of the jurisprudence of the Supreme Court, which they did in the last 8 years few times, they didn't like our judgments, they changed the law. If the court gave the rulings against their will, they were changing the law directly against this line, saying, we know better. So this, they can do it this way. This is a hard way, I would say, breaking the interpretation. The second was how to build authority of the court. 100 answers for that. Mine is be kind. As a judge, and while having hearings, I always apologize if there is 10 minutes delay of the opening of the hearing. I try to be kind to people, to respect parties. We judges cannot make big campaigns, but what we do, we meet people, we meet parties, we meet witnesses. We have to be kind and respect them. And this builds, from my perspective, the authority of the court, of course, in small steps. The next question was judgments contra legem. This is a fascinating question. I understand that this is the question between use and lex, which is what is more important, use or lex. And I have to say that this is what creates a judge. And this creates the situation when you need judgment. When really you need a judgment, it's when you see that the law interpreted straight way, the linguistic way, gives you the answer that you should do A, and you understand that fair is maybe B. So choosing this is very difficult, whether you can make a compromise or there are situations that you have to choose, whether it will follow strictly the law or will be just. I have to say that in my practice, sometimes I remember situations that I choose the second, to give the fair verdict, even if it was not in 100% according the standards of the law as if they were understood that time. I always give reasons why I change this line of interpretation. And the last question that I have to say something is about judicial discretion and boundaries. Thank you for this question. Again, very difficult question. My answer for that is common sense. I understand that in these situations, what you that you mentioned, the judicial discretion, have to be based on common sense, on logic, common sense, and honesty. And this is what I usually, when I really can't find the answer, it's too difficult for me, I get back to basics and I try to base on the common sense and try to be fair. Yes, not speaking too much, that would be my short answers. I'm very happy that I was here. Thank you for inviting me. It was very interesting, and please do not be angry that I have to leave in a minute.
Thank you very much. Thank you for your answers. It was a pleasure to have you with us today. See you. Please, dear Anna, you're welcome.
Yeah, I also have like 3 short points. When it comes to improvement or building the authority of the judiciary, of course, it cannot be based on just communication. And I fully support this, what was said by Judge Wiliński just a moment ago. But what I really find very interesting, and this is not something that is being applied in Polish courts and neither, I believe, in Ukrainian courts. So this kind of peer-to-peer approach. And, you know, when I talk, for example, with colleagues from the Netherlands, from judges from the Netherlands, they are the Scandinavian courts, they also apply the same. So they have like regular meetings, like every week, every month within the criminal division, civil division, etc., when they not only discuss like questions, some problematic issues, but this is also the space where they are secure also to share critics, somehow critics towards each other. Because, you know, for example, this is my experience from the time when I was working as a judge in Poland. I was working the first instance court. Generally, I was sitting alone in the panel because this is like a typical in Poland. In the first instance court, sąd rejonowy. And, you know, actually every judge is kind of a single, is individual. He or she believes that all her decisions are the best and only one that are just. And also we know each other very well, who is a bad judge, good judge, you know, in a sense, who works, you know it. When you, the same as I believe in the academia, that you know people. But because we do not have in Poland such a system of peer-to-peer training or cooperation, or however we call it, nobody is kind of talking about this openly, you know. So this is not something that the system can improve from inside. So this idea that there is like internal, this peer-to-peer approach among judges, where they have the space to learn from each other, somehow to improve thanks to this internal discussion, that is something that I would suggest. When it comes to this interpretation and politics, I agree with this what Judge Wiliński just said a moment ago. But in the ideal world, there is like a pure separation between legislation, between judiciary, and this is the judiciary to interpret the law. But once again, I will refer to example from Poland, which is, I would say, kind of embarrassing, because it shows that also judges try to adapt, you know, because I believe that Mr. Szwed would agree with me that even when we do not change the grounds for application of detention, it is sufficient that the Minister of Justice has changed for this more radical, more strict and demanding detention, and the number of decisions where judges decide to apply detention is increasing. And objectively, it shows that there is this, despite of lack of changes in the legislation, there is this unfortunately tendency to somehow adapt to the expectations of politicians, which is absolutely not good. And this is what should be criticized, I believe. And one last point from my side, you know, we are talking about judges that we are trying to also that we are trying to present judges only as, you know, good also. But, you know, I think that it must be said, when we talk about the dismantling the rule of law in Poland, it was made by lawyers, it was made by judges also. There were judges who were involved in dismantling the system of the rule, the system of independent judiciary. They were dismantling the rule of law. So it's I think very, very important that we cannot see like judges that we are like, I'm sorry, I'm sometimes telling about myself that I'm a judge. It's, you know, 17 years make a person believe somehow. But this is what is really important, that like dismantling the rule of law in Poland, it was made by lawyers and also by judges. So it's kind of a warning from my side. Thank you.
Thank you very much, dear Anna and dear Dr. Marcin Szwed. You're welcome.
Yes, I would like to respond to questions. First, Professor Trykhlib, if I understand correctly, asked me about the cooperation and between the government, judges, and NGOs in strengthening the rule of law, right? Yeah. So in Poland, we are in a very unusual and difficult situation in which there are various works on how to restore the rule of law. And so far, I cannot really criticize the attitude of the government towards NGOs. So, for example, we as a Helsiński Foundation, we are invited to the meetings of intergovernmental team on the restoration of the rule of law, in which various stakeholders like judges, NGOs, lawyers take part, and we talk about various proposals. So I think this is a positive step. Also, the parliament organizes public hearings on some important bills like constitutional tribunal reform, national council judiciary, or abortion law. Also, NGOs were invited. So I think these are very positive developments. Also, we are we have opportunity to file our legislative opinions in writing. So I think these are some positive steps, and very positive when you compare them to land justice situation. Of course, there are some areas for improvement, but generally I will assess this positively. I think the bigger problem than the cooperation with NGOs is that I sometimes feel that there is a lack of clear vision of the current government on which way to restore the rule of law should be taken. This concerns especially the status of these unlawfully appointed judges, or for example, the restoration of the independence of public television. I sometimes feel that the government should be more clear in formulating their vision on what should be achieved. And with regards to cooperation with judges, well, the situation here is also sometimes difficult because judges were also, of course, victims of the actions of the law and justice, and that's why they sometimes react very emotionally to differences of opinions on how to deal with the restoration of the rule of law. But of course, this is to some extent understandable because of their also being victims of this situation. And nevertheless, to conclude, I think that at the moment there is this discussion on what should be taken, and we as NGOs are given a chance to present our opinions, and we are part of the discussion. So this is also important from my perspective. And I would like also to briefly respond to the question of Mr. Yakimenko concerning this interpretation of law. This is interesting to me because this concerns the problem of how to ensure the uniformity and stability of case law without threatening the judicial independence. And that was actually the topic of one of the research grants that I recently proposed with my colleagues. It was unfortunately rejected, but maybe in future we can think about some international cooperation. But generally, I agree with Professor Wiliński and Dr. Adamska-Galant that politicians shouldn't be given the power to issue binding interpretation for judges. This would be clearly violating judicial independence, because the Supreme Court of the United States said that it is the duty of courts to say what the law is, right? And this is quite important. However, of course, when we talk about non-binding interpretations, for example, Parliament may present some purposes or present how do they interpret their own law in explanatory statement to the bills of law, and this could be, of course, used only as a supplementary source of interpretation of law. This cannot be binding for Parliament, but for court. But sometimes it is useful to look into that into the legislative works of the law, to the explanation of the law, to look what is the what was the ratio legis of given law. So it is the power to interpret the law should be given to courts. Of course, there's also yet another question whether what competences should be given to courts to make this case law stable and uniform. So, for example, in Poland we have these interpretative resolutions of the Supreme Court, which are theoretically non-binding for courts. Usually the courts follow them, but sometimes they do not. And even in some cases concerning human rights, for example, we had this famous case concerning detention of post-conviction detention in this special center. Many courts disregarded interpretative resolutions of the Supreme Court, and this is, of course, on one hand problematic, but on the other hand, judicial independence, of course, requires that judges should be given some freedom of interpretation and autonomy in application of law. So, very interesting question. Thank you very much.
Yeah, Timur, you want to react?
Yeah, a tiny remark, if I may. That's very interesting. Thank you so much, Mr. Marcin, Szwed. That was for your attention to my comment. First of all, I would say it's not necessarily dictate to judges what to do, but sometimes there is a contradiction between judges themselves. They cannot decide on one interpretation. There's a conflict inside judicial branch of power. And then we have to choose one or another interpretation, or another line of the judicial case law. And here's a matter of choice. It's a matter of politics, actually, to choose which one is correct. And here I think legislator, can interfere, when the judges cannot themselves decide on the right interpretation for a long time, and all society is waiting. That's number one. And secondly, when it comes to United States of America, you quoted Marshall, Judge Marshall. It's a very good quotation. But in fact, in the United States of America, they have judicial deference. And it's a very famous Chevron case. When judges said themselves, they relinquish their authority to interpret to administrative agencies which are specializing on special areas. Or there is another kind of deference when judges say, when the author of rules, administrative rule, interprets its own regulation, judge should not substitute his own interpretation. So that's also not so clear, I think, even in United States of America, with judges, Gullivers, or I would say very powerful judges. Yes, but thank you so much for your remarks. I did value them.
Yeah, thank you very much. I think that so we have different legal traditions and legal systems. I mean, common law and Germanic legal family, but definitely we have sometimes some experience could be also perceived. So thank you very much, dear speakers, dear discutants, dear audience, for your great questions and for your engagements, comments. We would like, together with Professor Monika Florczak-Wątor, we would like to announce that on the 1st and on the 2nd of July, we will have our final conference of our project, which will be held in hybrid format, actually online, but also in Krakow at the Jagiellonian University. So you're very welcome, and we will keep you updated. And also, I would like to emphasize that the struggle to establish the principle of the rule of law in both Poland and Ukraine should be a permanent process, which is a key value and the foundation of every democratic state, and the goal of which is actually to effectively ensure and protect human rights. And considering the post-communist legacy of both states and I would say the specific features of our legal cultures, I think that the implementation of the rule of law is especially acute and more relevant than ever, not only as a necessary condition for joining the European Union for Ukraine, but also for being in European Union and for effective interaction with different European Union institutions and other member states inside the European community. And only by uniting our efforts, I mean the efforts of scientific community, civil organizations, which are the key subjects of control and the so-called supervision of public power, so to speak, they are watchdogs, as Anna already mentioned, and also the engine and perpetual motor of reforms and progress. But also very important is feedback from the judicial system. First of all, from higher courts, which put theory into practice and which form legal doctrine and case law as well. So these models of patterns, if we can say, of interpretation and proper application, if we could say in such words, of general legal norms and also principles, and demonstrate actually in real life the implementation of separate requirements of the rule of law and administer justice. So without Supreme Courts, it is impossible to reach the final goal. In this regard, it is certainly necessary to increase the level of trust in the judiciary, since it is a key indicator of the real protection of human rights, as the European Union has repeatedly pointed out, which ultimately formed the basis for the decision to open accession negotiations with Ukraine. On the other hand, in Poland, there are also positive signs about the restoration of the rule of law, and NGOs here, together with scientific community, play a very important role in this process as well. Accordingly, of course, the principle of rule of law is very broad, and we would like our today's more optimistic note with hope for a future with rule of law in Ukraine and Poland. So thank you again very much for being with us today, and see you see you again. Have a good evening and take care of yourselves. Bye.
Thank you very much. All the best. Take care. Bye.
Thank you very much also from my side to all the speakers and participants.